for delivery of orders, item number 1.
Before that, any mention from anyone? Please mention.
May I seek Your Lordship's indulgence in making mention with respect to Part 2, item number 11.
Part 2, item number
11, Lordship.
11.
Yes, Lordship. With regards to this case, Lordship, we had recently received an instructions from our client saying that they want to settle the matter via Lok Adalat. We had just informed our learned friend, so if this matter may be, if they may be allowed to take instructions from their clients regarding this aspect.
Mediation or Lok Adalat?
Lok Adalat, Lordship.
Why don't you go for mediation?
Lordship, we have no knowledge about this, so if we may be
We've just
given
informed
time
them
as
this
well.
morning. So let them take instructions from their clients. From us, we want to settle the matter via Lok Adalat or mediation.
Please write down Mr. Aldrin Zor Hanmoya, Learned Counsel for the respondents. Respondent number 1, I think,
Yes, correct.
submits that his client is agreeable to settle the matter either through Lok Adalat or by way of mediation. And you are Ms. Ropari.
Yes,
Okay.
Lordship.
Stop Ms. Ropari, Learned Counsel for the appellant on the other hand, submits that she has no instructions in this regard and prays for some time to receive instructions. In view of above, matter stands adjourned to be listed again
Next week, Lordship.
in the next week.
Yeah.
The parties concerned, the rival parties shall inform the court as to whether they are agreeable to settle the matter mutually through Lok Adalat or by way of mediation. All right.
Deeply obliged.
Next, any other mention?
If I may seek Your Lordship's indulgence in mentioning hearing item number 15. My Lord, if this matter could be taken up after 2 weeks.
Which matter?
Hearing item number 15. It's a jail appeal, my Lord.
You are mentioning on behalf of?
On behalf of Mr. Eflal Engliana, the amicus.
After 2 weeks.
Yes, my Lord.
What is the difficulty?
My Lord, we still haven't done with our filing yet.
You still have not?
Done with our filing.
Filing?
Yes.
What
Yes,
filing?
my Lord. Filing of the petition.
You don't have to file any petition. You're the amicus.
That's the instruction I have received from my senior.
See, court has appointed you as amicus. Paper book is prepared by the registry.
Yes, my
You
Lord.
don't have to do anything. You have to just read and assist the court. That's all. There's no question of filing anything. Okay, please write. A mention has been made on behalf of Mr. Eflal Engliana, learned amicus curiae, appearing for the appellant, stating that he has some personal difficulties to conduct the case today. And therefore, matter will be posted again after 2 weeks. PP, any objection?
Yes, Your Lordship, we have no objection.
Okay. Since the prayer is not objected to by the other side, matter stands adjourned to be listed again after 2 weeks for hearing. All right.
Much obliged.
My Lord, for item number 4 and 16 of part 2, my Lord.
One at a time.
My Lord?
Four first.
Yes, my Lord.
You are the. Your name is not there.
My Lord, item number 4 on behalf of Tila Nunciama, my Lord.
What
He's
do you
out of
want?
station, my Lord.
What do you want?
If the matter can be taken up after a week, my Lord.
Okay. Mr. T. Lal Nusiama, learned counsel for the appellant, is said to be out of station. And on a mention made on his behalf by Mr. J.H. Ricky Lalwatwela, Learned Counsel. Matter stands adjourned to be listed again after a week. Now, have you informed the other side?
Yes, my lord.
Okay. It is submitted that the counsel for the opposite party have also been informed. All right, list accordingly.
And my lord,
Then
in
item
number
16.
16.
Yeah, what do you want?
My lord, same prayer. The leading counsel is out of station, my lord.
And you have taken the consent?
Yes, my lord.
Okay. Mr. J.H. Ricky Lalwatwela, Learned Counsel, for the respondent, submits that he is led by Mr. T. Lanunsiyama in the matter, who represents the respondent. And since he is out of station, he prays that the matter be adjourned for 2 weeks. He also submits that he has taken the consent of the other side. In view of above, matter stands adjourned to be listed again after 2 weeks.
Obliged, my lord.
Lord, Part 2, item number 6, 8 and 9, these are criminal appeals, connected matter. This matter may be taken up after 3 weeks. Lord.
Why?
The leading counsel, the senior advocate, we need to take instructions from the clients.
Who is leading the case?
This item number 6, Surajit Datta.
Item number 6.
Yes, all
Surajit
connected
Datta.
matters. Yes, we need to take.
He is the leading counsel.
Yes,
He is a senior counsel.
senior counsel. So we need to take instructions from the clients and inform about the same to him also.
How much time?
3 weeks.
Mr. Roshan Subedi, Learned Counsel appearing for the appellant, submits that he is led by Mr. Surajit Datta, senior counsel, who is an outstation lawyer. And that since they are required to take some instructions from their client, he prays adjournment for 3 weeks. The said prayer is not opposed to by the other side. Accordingly, matter stands adjourned for 3 weeks. Yes.
Obliged.
For delivery of order, item number 1.
Okay. Just leave it there. So, in order to save time, I have jotted down the order.
My lord.
So, I'll just read the operative. To my understanding, the projection of the petitioner was twofold. One is that the grounds of arrest was not intimated in writing. And secondly, long incarceration. I have rejected the first ground for the reasons given in the order. But insofar as the second ground is concerned, keeping in mind the long incarceration and the records of the accused person being in conflict with law for the first time, taking that into consideration, I have allowed the bail application. Now, this is the condition imposed. Therefore, considering the period of his incarceration, the accused shall be released on bail in connection with Sessions Registration Case number so-and-so on furnishing a bail bond of Rs 50,000 with 2 sureties of the like amount, provided that one's surety has to be a government servant to the satisfaction of the learned special judge and the NPS ISO, and subject to the following further conditions. Number 1, the accused shall appear before the court of the learned special judge and the NPS on each and every date to be fixed by the court. Number 2, the accused shall not directly or indirectly make any inducement, threat or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to any police officer. Number 3, the accused shall submit his Aadhaar and PAN card before the learned judge special court and the NPS ISO, Mizoram. And lastly, the accused shall not leave the jurisdiction of the judge special court and the NPS Act ISO, Mizoram, without prior permission. The bail application accordingly stands disposed of.
My lords, if I may kindly make a submission. My lord, since he is a resident of Assam Therefore, perhaps the last condition might be a little, perhaps it could be reflected upon, my lords.
Which one? The last?
The last one, my lords.
Jurisdiction.
Yes, my lords.
No, that's
Because
okay.
it
You
looks
take
the
permission. You take permission, that's all.
Okay, very well, my lords. Understand. I'm so obliged, my lords.
For orders, item 12.
May it please your lordship, by filing this application, we have sought for an implement in the connected WPC number 128 of 2025. The connected WPC number 128 of 2025 was filed by the respondent number 1 for a direction to release a sum of rupees 1,90,9,585 with interest at the rate of 12% per annum by the Kala. My lord, we have submitted a complaint before the Kala saying that it was our land which is to be affected and not the land of the respondent number 12, whom the OP number 1 had purchased. And
See, Mr. Zoram Sana,
yes, my lord.
can you not approach the Kala
My lord, we have approached
instead of coming to this court?
we have approached the Kala, my lord. They have,
Now-
they have sought for a release, so we need to know the stand taken by the Kala.
What is the writ petition about?
The writ petition is for a release of the amount in terms of the 3G award dated 13
Who is the
2025.
counsel for the petitioner? Why are you keeping quiet? Come forward. What are you seeking in this writ petition?
My lord, the main writ petition is for the release of the awarded amount in the 3G award, which is
3G
under
award.
the name, my lord, which is under the name of the petitioner in the writ petition, my lord. And my lord, in the 3A, 3D, 3C, and 3G, the name of the instant applicant is not nowhere reflected, my lord. However, the writ petitioner in the main writ WPC 128 of 2025, this petitioner,
Then why is it not released to you? Why do you have to come to the court for release of the compensation? There's something wrong. Compensation is computed,
my lord,
award made,
it's already,
but amount is not given to you.
my lord.
Why? Why do you have to come to the court to seek for release?
That is the reason, it's unknown to us, my lord. That is the main reason why we are approaching this honorable court, my lord.
So the known reason now is that Mr. Zoram Sana's client also say that they are the ones who are the beneficiary.
However, my lord, in this aspect,
You tell me
My lord.
how does a high court decide such kind of thing?
my lord,
You say I am the one, you give me a release. He says I am the one. How will we decide? It's not possible.
as far as, my lord, the claim of the instant applicant, my lord, I would like to submit that the documents which the instant applicant is relying on is all
See, can we do one thing? Can we
My lord.
close the matter and relegate the matter to the Kala and to decide? No point keeping it here. They might file, they might not file affidavit, we don't know.
My lord, as
And
far as
in
my...
meantime, you require the money. Whoever
Yes.
is to get the money should get the money. Why should we keep it hanging like that?
That is there, my lord. However, my lord, as per my humble understanding, the 3G award is finally already published, my lord. So the determination of amount and all the other aspects are dealt with in the 3C, which is notified under the 3D. Regarding the objections, everything is all settled. And then finally, the 3G award was, my lord, finally published. Therefore, my humble prayer is that, my lord, submission is that, since the 3G award has already been published, which is final and binding, my lord, so there is no point of reverting back it to the Kala, my lord.
3G award is prepared under which provision?
National Highway Act, my lord.
National Highway Act.
My lord.
So,
So
is
in
there,
that
a-
regard, my lord, I have
is
one
there any
authority.
provision for reference?
There is a provision, my lord. However, it should be done before the publication of the 3G award, my lord.
No,
It's
Highways
all-
Act, I think it refers to the 2013 Act also. What is that provision which says that any objection or any reference to be made has to be before the final publication of the 3G award? Can you show me the provision?
This is, my lord, section 3C and 3D of the NH Act, my lord.
PC 3D.
My lord. My lord, if I may.
Yes.
This
What do you
is
want to read?
Section 3C of the NH Act, my lord. Hearing of objections. Any persons interested in the land may, within 21 days from the date of publication of the notification under subsection 1 of section 3A, object the use of land for the purpose of purposes mentioned in that subsection. This is subsection number 2. Every objection under subsection 1 shall be made to the competent authority in writing and shall set out the grounds thereof, and the competent authority shall give the objector an opportunity of being heard, either in persons or by legal practitioner, and may, after hearing all such objections and after making such further inquiry, if any, as the competent authority thinks necessary by order, either allows or disallows the objection. This is 3C of NH Act, my lord. And apart from that, my lord, this notification has already been published in the newspaper, my lord. And this is 3D, Declaration of Acquisition. Number 1, where no objection under subsection 1 of section 3C has been made to the competent authority within the period specified therein, or where the competent authority has disallowed the objection under subsection 2 of that section, the competent authority shall, as soon as may be, submit a report accordingly to the central government, and on receipt of such report, the central government shall declare by notification in the official gazette that the land should be acquired for the purpose of purposes mentioned in subsection 1 and section 3A. Subsection 2. On the publication of the declaration under subsection 1, the land shall vest absolutely in the central government, free from all encumbrances. Subsection 3, where in respect of any land, a notification has been published under subsection 1 of section 3A for its acquisition, but no declaration under subsection 1 has been published within a period of 1 year from the date of publication of that notification, the said notification shall cease to have any effect. And the relevant portion is this subsection number 4, my lord. A declaration made by the central government under subsection 1 shall not be called in question in any court or by any other authority, my lord.
That is regarding the acquisition.
My lord.
But regarding the dispute of payment to the parties concerned,
My lord, as I have already
That's a different
submitted,
matter.
my lord, the disputes and the amount of compensation, they are all already settled under section 3C, which is settled under, which is published under, notified under section 3D, my lord, of the act. My lord, determination of any dispute other than the amount of compensation are already settled under the 3C, which was notified under the 3D. So, my lord, those persons who are notified under the section 3D of the act can be given compensation. And in this regard, my lord, I have one authority, if I may kindly submit before this honorable court.
yes, authority with regard to?
With regard to the submission which I've made with regard to the determination of any dispute,
3D.
my lord,
Court, order passed by this court.
my lord. This is TLL Ramchwani and 5 others versus Government of India and 5 others in WPC 106 of 2021. My lord, in this case, it was held that the Kala constituted under the National Highway Act does not have any authority to make any correction or for that matter to pass any other orders in the nature of correction of an award or amend of the award. And my lord, once the award has been passed by the competent authority loses any authority to tinker with it in any manner whatsoever, my lord. This is in page, para number 14, my lord. So my point is, my lord, the 3G award which was published by the Kala is final and binding, and there is no point of, my lord, sending it back to the Kala for determination of the amount of compensation who is entitled for compensation, my lord. The 3G award is final and binding. My Lord, the relevant portion paragraphs are in 14, paragraph number 14, 15.
This was a case when the Kala had made some modification.
Exactly, my Lord. So there
But
is
in
no
the
point
present
of,
case,
my
there is
Lord,
no
remanding
modification.
it back to the Kala for determination, my Lord. And my Lord, one more submission is that the documents which my learned friend is relying upon, my Lord, they are all after the publication of the 3G award. The 3G award was published my Lord, 3A was published on 15/3/2024. And thereafter, my Lord, the Section 3G award was published on 30/4/2025 by the Kala, my Lord. 30/4/2025. And the documents which my learned friend are relying upon, which is the detailment order, spot verification report, and the detailment, all of the documents which my learned friend is relying upon is after the publication of the 3G award, my Lord.
What is this competent authority this is mentioned, which is mentioned? Who is this competent authority? And what are
My
the
Lord, this
powers?
is the additional DC, my Lord. Aizawl District.
No, in the Act. What do you mean by competent authority?
My Lord, as per the Act, my Lord, the competent authority means any person or the authority authorized by the central government, my Lord.
3A, subsection 3A.
My
So
Lord,
that is the
essentially,
Kala.
This is the Kala, my Lord.
Competent authority is the Kala.
Exactly, my Lord.
Now, in the writ petition, what is the response? Who are the parties?
My Lord, at this point, there is no response yet from the respondents, my Lord, in the main writ petition. Since the IAS was filed by my learned friend, we are going to the IA, my Lord, first.
All right, let them file the counter affidavit in the writ petition. We'll keep this pending
My Lord,
as of now.
if
Will
I
not
may
pass
take
anywhere.
your lordship to just page 9 of my application, my Lord. This is the report on objection under section 3C subsection 1 of the National Highways Act 1956.
Where? Page?
Page 9. A report on objection under section 3C subsection 1 of the National Highways Act 1956. The paragraph number 6, my Lord. The English translation is at page 12, my Lord.
This is under 3C.
3C. If I may be allowed to read, my Lord.
No,
Paragraph
just a
number
minute, just a minute. What is 3C? Let us see first.
3C, my learned friend has just read out, my Lord. Hearing of objections.
Translation.
Yes, there was a dispute between the present applicant and Mrs. Zhao Ming Tangi. And in paragraph number 6, if I may read, my Lord, regarding P. Zhao Ming Tangi land PP number PP 101 of 2007 and Puzoram Liana PP 100 of 2007 area. It is opined that there is error. Their lands are located at Viring to Sairang Road, National Highway 6 project and Aizawl Bypass NH06 junction. It is decided that their lands are to be verified at the spot. So Kala has admitted that there is error, and thereafter it had directed. Pardon? Thereafter it had directed for.
No. Who are these people? Who is Pizom Hing Tangi?
Pizom Hing Tangi is the landowner to which the petitioners had claimed that she had. Yes. The petitioner claimed that this Zhao Ming Tangi had gifted her the P Pata number 101 of 2007.
Zom Hing Tangi had gifted the Pipata to whom?
To Lalram Siami. Lalram Siami is the writ petitioner.
Petitioner, yes, my lord. In the main writ petition, my lord.
Only one petitioner, isn't it?
Yes.
My lord.
So you accept that fact? Land has been gifted to you
Gifted, my lord.
by Pizom Hing Tangi.
That
My
is
lord,
as
my
part of their pleadings, my lord.
And what about who's Puzoram Liana?
Zauram Liana is the husband, the deceased husband of the applicant, my lord. Deceased husband of the applicant.
So you're
We are claiming in the name of Zauram Liana and they are claiming in the name of Zhao Ming Tangi.
okay. So both your lands are adjacent to each other.
Yes, my lord.
Going by the serial numbers, P Pata 101 and one is P Pata 100.
Yes, my lord. They are adjacent to each other. So, in pursuant to this, my lord, decision, as per
Now,
verification
after
was,
this is what the verification
verification was conducted, my lord.
under this is under what 3C
Yes, my lord.
report of objection under 3C.
Yes, yes, my lord.
After this report, what happened?
After this report, a detailment order was issued wherein the surveyor, Arnal Yanfala, of Deputy Commissioner's Office was directed to conduct spot verification by detailment order page 13. Detailment order dated 17 July 2025. And thereafter, he had submitted his duty report, page 14, my lord.
Page 40.
English translation is at page 15.
Yes. Please read.
As per the memo indicated above, I have verified at the spot land belonging to Sri Zauram Liana and Srimati Zhao Ming Tangi, and these are my findings. The P Pata number 100 of 2007 was measured as per the P Pata dimension, 210 meters surface from Sairang River along the boundary with Srimati Zhao Ming Tangi, land covered by P Pata number 101 of 2007. GPS data was taken and the GPS data shows that Srimati Zhao Ming Tangi's P Pata is outside the alignment of Aizawl Bypass and NH06. So, mistakenly they are included in the award which we are to receive, my lord. Zhao Ming Tangi's P Pata is outside the alignment. And the map, the reference map, has also been enclosed herein, my lord.
No, you read the vernacular.
Yes. Atsunga memo number tardan ina soyangin dated 18/7/2025. Hian Aizawl Bypass Road NH064 lane in Tuanalai. Puzoram Liana Lekri Zhao Ming Tangi tiram spot verification ni turaro at kani angin na nakakala. Hetiang hikam hudana niye. Puzoram Liana P Pata number 100 of 2007. Hi P Pata dimension 210 meter surface million Sairang Luyatang. Nga P Zhao Ming Tangi Ram P Pata number 101 of 2007 nen anin rina ako sa kaniya GPS data la kani GPS data kan la at nga alandanin P Zhao Ming Tangi P Pata hi Aizawl Bypass and NH064 lane alignment pon aniye. Pon means outside, my lord. It's outside the alignment.
I think so. You're right. Pon means outside.
Yes.
Then what about your Pata?
Yes, my lord. Page 21, my lord. The reference map is there. Page 21.
No. As per the surveyor finds that P Zhao Ming Tanga's land P Pata is outside the alignment.
Yes, my lord.
But does it say that your land is inside the alignment?
The map would show that, my lord, page 21. Page 21 is the alignment.
21.
Yes, my lord.
Oh, these are. Don't you have legible copies? You're giving us a tough time.
My lord, it's very difficult to type. I'm sorry, my lord. It's a map. Our lands are showing adjacent to each other.
Anyway, you tell me one thing. It's difficult. See, we are not surveyors. We don't know. We have not done any course in survey, so I don't know what is what. Now, you tell me, after this, Kala has made that observation. Detailment was made. Surveyor went. Surveyor submitted a report.
Yes, my lord.
After that, what happened?
That is the reason they withheld the amount from the petitioners.
No, that report has not been acted upon till now.
Because of the pendency of the writ petition filed by them, my lord. During this process, they filed the writ petition. So everything was stayed.
So, was it stayed by which?
By the
which court?
Kala.
Oh, Kala stayed it.
Yes.
Court has not. This court has not given any stay order.
Any stay order, but Kala has stayed the matter due to the pendency of this WPC number 128 of 25.
So, Mr. Counsel, keeping in mind the steps taken, the surveyor made a report. Let the Kala take a decision. What is there? How do you say that Kala cannot do anything now?
My lord, that is a very interesting part, my lord. If my learned friend is going to rely on page number 21 of the map, my name is also there within the alignment, if you can hear it. Yes, my lord. Zoming Tangi is there.
No, both names will be there definitely
Exactly,
because
my
you are
lord.
adjacent
My
to
lord.
each other.
My lord,
But the report itself says that your Zomingkang SP Pata is outside the alignment.
my lord, with regard to this, I have one submission, my lord. The allegation of the applicant in the IA, my lord, is that the Kala committed error while passing the 3G award. And then by inserting the name of the respondent, that is from whom I have my pass, my lord. This is Zoming Tangi, in place of the deceased husband of the applicant, namely Zoram Liana. So, my lord, however, there is no documents or reports so that the Kala committed error while passing the 3G award. That is number one, my lord. By inserting the name of the respondent, number 12, in place of the deceased husband of the applicant. The report 15/7/2025, which we just produced, my lord, it simply stated that regarding Pizoming Tangi and Puzoram Liana's land, it is opined that there is an error and that the same is to be verified on the spot. And after that, the spot verification and the report was there. However, my lord, as I have submitted the authority, my lord, it is a settled law that once the treaty word is published under the NH Act by the Kala, the same Kala does not have the authority, my lord. So
Okay.
to make any corrections with regard to the award or the amendment of the award. And my lord, one small submission.
So show me the thing. 3G award. Where's that 3G award?
3G word is in the main petition, my lord.
Yes, I have the main petition with me.
My lord, just before that, if I could kindly take your lordship to annexure number 5 of the main writ petition, my lord. This is the page number 36. Page number 40. This is section 3D, my lord. If I could kindly, my lord, read out the notification. The relevant portion, my lord, if I may kindly.
Yes, read.
This is para number 3. And whereas the competent authority has received objections filed under section 3C, considered and settled the same appropriately. This is important, my lord. And then coming to the para before the schedule, and further in pursuance of subsection 2 of section 3D of the said act, the central government hereby declared that on publication of this notification in the official gazette, the land specified in the schedule shall vest absolutely in the central government free from all encumbrances. So this is the 3D notification, my lord. So my point is, my lord, belatedly, after after the publication of the 3G award was published, and thereafter, my lord, belatedly the Kala issued a detailment order 17/7/2025, and the spot verification was done on 18/7/2025, and the order was dated 22/7/2025. All after the publication of 3A, 3C, 3D, and 3G, my lord.
Now, this is
So my point
3D.
is,
Where is 3E and G, FG?
3G is, my lord, in page number 44, Annexure 7. So, the main petitioner in the writ petition name is in,
Page 44.
my lord, is the 3G award.
44. Where does it say 3G award? It's a 3G estimate.
My lord, this is
Annexure
serial
7.
number 75, my lord.
Huh?
Serial number 75, page number 47, my lord.
No, I'm concerning the beginning part. 3G. Where? How do you say this 3G? Page 44 says 3G estimate.
Yes, my lord, this is the 3G award, my lord. There is no other notification as per my,
3G award is only on the basis of a format,
my lord.
like a chart.
Exactly, my lord. This
There's
is
there's no notification saying that 3G award is declared.
the notification portion is, my lord, it's not within my,
Then what is the date? How do we know the date of 3G award?
my lord, is in the last page. Page number 47.
47.
This is countersigned by the additional DC 3425, my lord. The date is there.
But page 44 says it's estimate. It's only an estimate. Amount involved is how much?
Amount involved with regard to the instant
1 CR.
my lord, 1,09,09,585, my lord. However, my lord, my point is, if I have already mentioned, my lord, the objection under the National Highway Act on this 3D, 3C is already settled. However, belatedly, the Kala have sent the surveyor by detailment order and spot verification was done. So, my lord, as I have mentioned, after the publication of the 3G award, the competent authority does not have any power, my lord, to tinker with the award, my lord, or does not have an authority to summon or reconduct the spot verification so that the 3G award may be changed, my lord, modified. And the spot verification was conducted belatedly on 15/7/2025, which is around 2 months from the publication of the 3G award, my lord. And at the time when the Kala, this is the OP number 7 in the IA, they conduct the hearing belatedly. My lord, we were never notified or summoned to attend the said hearing. Therefore, my lord, the hearing was conducted behind our back. We were never given a chance. And my lord, one more last point is that since the 3G award is not challenged yet, my lord, so my submission is that, therefore, the 3G award dated 30/4/2025 still stands. And as per the 3G award, dated 30/4/2025, the instant applicants, they are not in any manner an interested person. They are not interested person. Their name is never reflected in 3A, 3G, 3D, and the 3G award. So they are not an interested person. That is the reason why
Okay.
there is no point of impleading the instant
Okay.
applicants, my lord.
Okay, now there are so many of them, isn't it, under the 3G award? Has anybody been paid compensation?
My lord, they are given,
Anybody has been
they
paid?
receive amount of compensation commencing from 26/5/2025. The other
Others have received.
others, my lord.
Okay. Yes, who's paying for Kala? There's nobody for Kala.
My lord, the authority which the relying upon.
No, see, I'm not disposing of your IA or neither the writ petition. I intend to adjourn it. Who is Zoming Thangi?
So Mingtang is the person from who gifted me the,
Oh, you the one
My
who
lord.
gifted you. Okay. She's the pro forma respondent. Yes, who is appearing for the respondents? What is your take in this matter? In the writ petition?
Yes, Your Lordship. I'm representing the state and we still need time to file the affidavit in opposition, Your Lordship.
Are you representing the Kala also?
No, Your Lordship.
Anybody appearing for Kala? Who is 11? The pro forma respondent.
My Lord, I'm appearing on behalf of respondent number 7 and 10 in the main petition. And NHIDCL and in respondent 8 and 11 in the IA.
My lord, this matter can be relegated to the Kala because if what my learned friend says is correct, then they will get the amount. But if they're not to be affected, then they will not get. They're afraid because they will be outside the alignment. Because they're afraid and they're trying to use the authority passed by your lordship, by this honorable court, to substantiate their fraudulent claim, my lord. Kala has realized that there has been some error, so he has conducted a verification, and he says Zhao Mingtang is outside the alignment. How can you receive a compensation when you are outside the alignment? Now they are afraid because Kala has realized the mistake he had committed.
So let Kala come, we'll see. At this stage, we're not taking a decision. Now, 6 to 11, notice was issued on 7/11. Then for 7 and 8, you are there. 7, 8, and 9, correct?
In the main petition 7 to 10,
7 to 10.
yeah.
Okay.
In the IA 8 to 11.
Are you going to file any affidavit?
Regarding to the writ petition. Yes.
My lord, can I be pleaded in the writ petition? Because the reason I've sought for impleadment is because to know the decision of the Kala when they file the affidavit. If I'm not impleaded, then I will not get a copy of the.
Not at the moment. At the moment, we'll adjourn this matter. Let the affidavit come in the main writ petition first. In the main writ petition, you write, parties are represented by the respective councils, except for respondent number 6. Have you filed your Vakalatnama?
Yes, Your Lordship.
You have filed Vakalatnama. This is item number 12. Learned counsels for the respondents seek for how much time?
3 weeks' time.
3 weeks' time. Further 3 weeks' time to receive instructions in the matter and to file counter affidavit. The prayer is allowed. Next para, it is seen that neither AD card nor unserved notice has come back from respondent number 6. So under this circumstance, the petitioner shall take fresh steps. What is this? How is this? How is it, sir? Hmm? Hmm. Okay, okay. Okay, what is the last line? You cancel that, not required. It is seen that AD card has returned back from respondent number 6, but no one appears for respondent number 6 today. So under the circumstance, no, stop. Under the circumstance, you cancel that. From the issue involved in the instant writ petition, a response from the respondent number 6 would be necessary to adjudicate the matter. Stop. Since no one appears for respondent number 6 today, the matter stands adjourned. To enable the respondent number 6 to be represented by the next date. List the matter again after 3 weeks. This Kala is from where? Aizawl. You take up the matter, Ms. Vanesiami, through your office. You inform the respondent number 6 that they need to respond to this. And they may engage anybody, even they may utilize the service of the government advocate. Then in case of the writ petition, the IA, you write, considering the issue involved in the main writ petition, this court is of the considered view that the application be deferred for consideration pending a response of the respondent number 6, Kala, CALA, it's an abbreviation, in the main writ petition. List along with WPC number 128 of 2025. All right. Yes.
Item 13.
May it please your lordship.
Yes.
Lordship, CD was called for yesterday in this matter.
What is there in the CD? Have you gone through it?
Yes, Your Lordship.
Keep it there.
And it stated that the present appellant is being the accused from the statement of the accused who is arrested. From his statement. But however, the statement is not annexed in the CD. It only written that from the statement of the accused.
Where is it in?
It's in the last page.
Last page.
Second last page, I guess.
Second last page. So why don't we allow the application and ask him to report to the IO so that IO can do the investigation?
Your Lordship, in that
He,
regard,
it seems he's absconding.
absconding. And my submission is that since the offense involves commercial quantity and the rigor of section 67 is strictly attracted, and at this stage, the appellant has no ground to state that he is not guilty because no statement has been given by him. And moreover, the offense under section NDPS is a commercial network system. So custodial interrogation is necessary, Your Lordship.
Lordship, if I may, the present petitioner resides at Lucknow since many years now, and no summons or notice was issued at his premises to say that he is absconding.
As can be seen from the CD, Your Lordship, his parents, especially his mother, has a knowledge, and she is not cooperating with the case IO.
What is this letter to the judge special court, prayer for extension of investigation? What is the date? Is it 28/10/2025?
I'm not sure, Your Lordship.
Now, what has happened to this prayer? It was only a prayer for 60 days extension.
Yes, it was granted.
Granted?
Yes.
Then 60 days has lapsed since then. This was in October last year.
And from the CD, it can be seen that the investigation cannot proceed due to the abscond of the present applicant, Your Lordship.
Yes, what do you say? From the case diary, it
Lordship, may
appears
I
that you are evading the investigating agency.
Lordship, as per my instruction, no notice has been served to appear before any investigating officer, and he is not absconding since many years now. He resides at Lucknow. His mother resides at Aizawl, that is true, but he stays at Lucknow. Also, Lordship, if Lordship allows this petition, will appear before the IU as your Lordship directs. Lordship may impose a condition to appear before the IU and accordingly will appear.
He is otherwise a resident of the state, isn't it?
Yes, Your
Yes, Lordship, his permanent address is of the state.
What is he doing in Lucknow?
Lordship, he is a renowned music director, so he is taking up some classes for composition of music. He is also founder of the Mizu Cardinal Choir. Lordship will fully investigate, he will appear before the IU.
Yes, anything else?
Yes, Your Lordship, another thing is that it can be seen that he has a knowledge. So no need to send formal notice because his mother has been instructed. And since his mother is not cooperative to the case IO.
Well, that's why you need to
He-
investigate. So at this rate, you'll not be able to break through anything.
Yes, Your Lordship.
Let him appear before the IO and let the IO take necessary steps.
Yes, Your Lordship.
That is the best course of action. Hard Miss.
P. Gupta.
Sorry?
P. Gupta.
P. Gupta, learned counsel for the petitioner through RVC. Stop also heard Ms. Vanesiami, learned additional public prosecutor, Mizoram. Stop by filing this application under section 482 of the BNSS 2023. The applicant prays for grant of anticipatory bail since he apprehends his arrest in connection with registration of case number EXN-73/2025 by the Mizoram Excise and Narcotics Anti-Narcotic Squad under section 21(c) of the NDNPS Act 1985 and under section 6(1), 7(3) of the MLP Act 2019. Stop. The learned counsel for the petitioner submits that the petitioner has no involvement in the aforesaid case. But at the same time apprehends that he will be arrested since the contraband substances was recovered.
It was seized, yes.
It was seized from the premises occupied by the petitioner.
Not occupied, Lordship, he is the owner. It was occupied by the accused named in the information report.
On the premises,
He's the landlord of the
on the premises of the petitioner, which was occupied by the accused person. Stop. This court, upon considering the projection made by the petitioner, had issued notice and directed the learned public prosecutor to produce the case diary. Stop. The Ms. Vanesyami, learned additional PP, has produced the case diary. Wherein it is seen that the investigating authority had sought for extension of time for investigating the matter by submitting an application before the special judge, before the Judge Special Court under Indian NPS Act on 28/10/2025. To stop, the learned additional PP submits that the application was accordingly allowed, but the investigating authorities are unable to get any cooperation from the petitioner, since he is not residing within the state but has absconded to another state, and thereby making it difficult for the investigating team to apprehend him and complete the investigation. Next para, the learned counsel for the petitioner submits that the petitioner, in fact, is currently residing in Allahabad, where he is engaged in promoting music. What
Yes,
are you do?
Lordship.
What do you do?
He's a music director and composer.
Promoting music
The
as a music
paragraph-
director as well as a composer of music. Stop. She submits that, in fact, the petitioner is the founder of the Mizo Cardinal Choir, which has performed for the highest dignitaries, including the President and Prime Minister of India. Stop. Further, he has no records of any criminal antecedents in the past. And that in the event of being granted anticipatory bail, the petitioner is willing to cooperate with the investigating authorities Next para, considering the submissions made and upon perusal of the case diary, this court is inclined to grant anticipatory bail to the petitioner as prayed for. Stop. It is therefore provided here under that the petitioner on being arrested shall be released on bail by furnishing a bail bond of rupees 50,000 with 2 sureties of the like amount to the satisfaction of the arresting authority. Stop. The when can you approach? When can you come?
Lordship, within a month's time be granted to
A
appear.
month's time will be too long a time. Today is what, 24th? You report by 20th of April.
Lordship.
The petitioner shall surrender before the, shall appear before the investigating officer on or before 20th of April 2026. Whereafter, as directed herein above, upon his furnishing the bail bond and the requisites, he shall be allowed to remain on bail. Stop. The petitioner shall, however, extend all cooperation with the investigation by appearing before the investigating authority as and when he is asked to do so. Stop. The petitioner shall also not involve himself or influence any of the witnesses or conceal the materials which are being considered, which are being investigated into by the investigating authority. Anything else, Ms. Vanessiami?
That he will not leave. He will not leave Mizoram without prior condition. Submit permission.
Lordship is residing at Allahabad. It will be difficult for him to not leave the jurisdiction. He will appear whenever the IU asks him to meet. Otherwise,
No, you'll take permission, that's all.
all right. Lordship.
The petitioner shall also not leave the jurisdiction of the investigating authority without prior intimation and permission. I think that should do. The bail application calling stands disposed of as allowed.
Much obliged, Lordship.
Item 14.
That was item number 13. Huh? Yes.
May I please, Your Lordship? This is a bail application filed on behalf of the petitioner Len Pangaizwala, arising out of Vairangti Police Station case number 44 of 2024 under section 22C, 25 and 29 of the MPS Act. And my Lord, my primary submission is on the ground of parity. My Lord, that the co-accused Lel Fagzwala, who was apprehended in the same alleged transaction, was already granted bail by this honorable court. On the ground that there was a violation regarding communication of ground of arrest, which is a constitutional safeguard under Article 22(1) of the Constitution of India. My Lord, we annex the order in Annexure 4, page number 94.
94.
Yeah.
Okay. Just a minute. Before that, let us just try to understand your history. There's a trial going on now.
Yes, sir. My lord.
Trial.
Yes.
And then criminal trial number 10 of 25.
Yes,
Then
my lord.
how many witnesses are there?
Uh, 6 witnesses, my lord.
How many have been examined so far?
My lord, they are already examined.
They've already been examined,
Yes,
all of them.
my lord.
Then what is the stage now for defense?
It is in the stage of defense evidence.
Defense evidence.
Yes.
When is the next date?
My lord, I'm not sure.
You're not sure.
Yes.
If you get all the instructions from your client, court might want to know all these things. You are a permanent resident of the state?
Yes,
where
my
where are
lord.
you from? You are from Kolasit,
No, my lord, I'm from
Vairengte.
Vairengte.
Petition is from Vairengte. Okay. Now, what was recovered?
35 kg of methamphetamine.
35 kgs of methamphetamine. And how many persons were arrested?
2 persons.
Wh-
My
what is the-
lord.
What is the date? When?
27/9/2024.
27,
9/2024.
24. From where was it recovered?
My lord, it is recovered from 2 autorexo. 18 kg from the autorexo of the petitioner Len Mangaizuala.
And the
And
other?
17 kg from Lel Fagzuala.
Who has got the bail now?
Yes, my lord.
2 auto rickshaws. What they were doing with that, roaming around with 35 kilograms of methamphetamine? They were trying to sell it or what?
My lord, the autorexo is not theirs.
What were they doing in the auto rickshaw? They hired that auto rickshaw
Yes, my lord.
or they were driving the auto rickshaw?
Yes, my lord.
No, it
They are,
cannot be-
they are driving the autorexo.
Huh?
They are driving.
They were driving.
Yes, my.
They are just the driver, Your Lordship.
They are the drivers of the auto rickshaw.
Yes.
My Lord.
There were no other passengers.
Yes, my Lord. Because
Then
the accused petitioners were hired by some persons, but the investigation revealed that person and did not investigate that person. But some person hired the accused petitioner for delivering of goods, and the essay was recovered from black bag, and
kept in the auto rickshaw.
yes, my lord.
There were no other person
Yes, my lord.
except for the accused person.
Yes, my lord.
Driving the auto rickshaw.
Yes, my lord.
So then you were in possession. You were in
My lord,
conscious.
the
You were in
autorexo
conscious
is not
possession or
No,
what?
my lord. They have no conscious possession. They
See,
did not know because in the evidence we already exposed about the essay was not open, and the back of the essay was not opened by the accused petitioner. It was opened by the police personnel.
see, I'll tell you. One of you submit. Okay, don't submit together. Normally, one should submit. You can instruct her, and she can communicate to the court that way. So, your bail application on the grounds of parity.
Yes, my lord.
And,
As there was no written ground of arrest attached to the charge.
Arrest was done on 27/9/24.
9/2000. Yes, my lord.
And what is the judgment of the Supreme Court? When was it passed?
My lord, in Prabir Parkayastha versus State, and in Vihan Kumar versus State of Andhra Pradesh, and in Mihir Rajesa versus State of Maharashtra, the Honorable Supreme Court held that the grounds of arrest must be furnished in writing and in a language understood by the accused.
Okay. Which was the first judgment amongst those three?
Prabir,
When was it rendered?
2024,
Date, month?
May.
You don't have the date? Just May 24?
15 of May 2024.
Okay. Your arrest is on 27/9/24,
Yes, my
after
lord.
that judgment. Okay. Any citation regarding parity? Any decision? Just find out, I'll come back in 5 minutes. This is the what? Skin cover. You also go through this in the meantime. Anything to be said here? Give it to her. Yes. Could you find any judgment?
Yes, my lord. Your lordship, may I hand up the judgment?
Yes. No, these are already known. I was talking about parity. In parity.
My lord, we attached that in an excerpt for page number 94.
Page number
94.
94. 94 is the co-accused person. Correct?
Yes, my lord.
Dalfak Zwala. He's the co-accused person.
Yes, my lord.
You're saying that since he's released, I should also be released. So I was asking you whether you have any decision on that if co-accused is released, he also should be released. Yes, what do you say?
Yes, Your Lordship, regarding parity, one cannot be released on the sole ground of parity, since parity is not a mandatory rule. It is only a guiding factor. And one person has to be assessed as per his own role and involvement. So parity cannot be a sole ground to release the accused on bail.
Okay, now what is the thing what is the element here by which we should not be given the parity?
Your Lordship, in the instant case, there were two accused, but however, Your Lordship, the seized contraband article were seized from their own auto rickshaw. So one have to explain. Separately. So it cannot go on together.
How much was seized from the present petitioner?
18 kilos.
18. And the other one?
And the other one is 14.
No, my lord, 17 kg was seized from the petitioner.
This petitioner?
Yes, my lord.
17.
Yes, my
And
lord.
from the other?
18 kg.
18. 17 plus 18 equal to 35 kg.
35 kg.
Gone are the days when recovery is done in grams, milligrams.
Exactly.
It's become
In
kilograms. Later on, it will become quintals. Very difficult situation.
And Your Lordship, my another point is that now, since trial is almost concluded, and there is no reason to be releasing on ground. And as far as grounds of arrest, Your Lordship, there are certain factors, materials, which can be seen that there is substantial compliance of Section 47. Since the accused was represented by his counsel and he is aware of what he is being held of. So there is a substantial compliance, and in that regard, his bail application must be rejected.
But can you show me somewhere from arrest court surrender form? Where is that? There is the only one.
Yes,
Apart from that, anything has been given in writing?
no, Your Lordship. The only thing is that the accused was produced before the CJM in time.
Okay. Please write. Heart, miss. What is your good name?
Vanal Moanomi.
Banlal?
Moanomi.
Okay. Heart, Miss Banal Wanomi, learned counsel for the petitioner. And Ms. Vanessiami, learned additional public prosecutor for the state. Stop the petitioner by filing this petition under section 483 BNSS 2023, read with section 37 of the NDNPS Act, praised for his enlargement on bail. Stop the learned counsel submits that the petitioner, along with another co-accused person, were arrested on 27/9/2024 in connection with recovery of a total 35 kilograms of contraband substance suspected to be methamphetamine. Stop. The contraband substance weighing 17 kilograms was recovered from the auto rickshaw driven by the petitioner bearing registration number MZ05A8955, while the contraband substance weighing 18 kilograms was recovered from the auto rickshaw driven by the co-accused person bearing registration number MZ05B1904. Stop accordingly, Variante PS case number 44 of 2024, dated 27/9/2024, under section 22 bracket C, 25 and 29 of the NDNPS Act was registered and an investigation conducted. Stop. Upon completion of the investigation, the charge sheet was submitted by the case IO, and as many as 6 prosecution witnesses have been named to prove the case of the prosecution and against the accused persons. Stop. The learned counsel for the petitioner submits that as on today, all the 6 prosecution witnesses have already been examined, and the case is at the stage of defense evidence.
Your Lordship, if I may, only 5 witnesses were examined and 1 is dead, so 1 cannot be examined.
Okay. 1 is dead.
Yes.
I see. So go back in the earlier paragraphs. Prosecution named as many as 6 witnesses. Then no, as on today, 5 prosecution witnesses have been examined. and that one of the prosecution witness has expired. Then what was the last part? That's the last part. Okay. Next para, the learned counsel submits that the petitioner has no involvement in the case, and in fact, he was only hired to deliver the goods. Which he agreed to do so in good faith. She submits that the petitioner was not of the knowledge about the contents of the goods asked to be delivered, and therefore the petitioner is innocent. Stop. She further submits that the co-accused person had also filed bail application number 2 of 2026, and this court, upon considering the same, by order dated 26/2/2026, had granted bail, primarily on the ground that the grounds of arrest had not been furnished to him in writing as mandated by the apex court decision in Mihir Rajesh Shah versus State of Maharashtra and another 2025 SCC online SC 2356 and Prabir Purkastha versus State bracket NCT of Delhi close bracket 2024 INSC 414. Stop. The learned counsel has drawn the attention of this court to the arrest/court surrender form, wherein against serial number 8, it is stated that the accused, after being informed of the grounds of arrest and his legal rights, was taken into custody on 27/9/2024 at 11 p.m. in Varente police station. Stop. She submits that the contents of the form are basically a format, and by any means do not meet the requirements of furnishing the grounds of arrest in writing. In terms of the apex court decision. Stop. She therefore submits that for this reason, and also on the ground that the co-accused person has already been released on bail, the principles of parity is also attracted, and therefore the petitioner may be released on bail. Now, in addition to the above two authorities, the Learned Council relies upon the case of Vihan Kumar versus State of Haryana. What is the citation? This is from reported in so and so, okay? Fill up the record. Next para. Ms. Banesiami, learned additional public prosecutor, on the other hand, submits that the arrest oblique court surrender form would go to indicate that the petitioner is aware as to why he has been arrested, since recovery of the contraband substance has been made from the auto rickshaw driven by him. Was there any bail application earlier before the trial court? Before the special court, did you apply for bail earlier?
Yes, my lord.
How many times?
One time. We annexed that in annexure number 3,
When was it?
5/12/2025.
Okay. She further submits that the fact of the petitioner having approached the court of special, the Laureate trial court for bail subsequent to his arrest would also go to indicate that the petitioner is aware of the ground of his arrest and was represented by a legal counsel. So, such being the case, the petitioner cannot say that he is not in the knowledge about the reason for his arrest. Stop. As regards parity, Ms. Vanesiami, learned additional PP, submits that the nature of involvement of the accused persons is not similar, in view of the fact that the recovery was made from two separate auto rickshaws. Stop. Therefore, the principles of parity cannot be applied without taking into account the degree of involvement of the petitioner in the case compared to the co-accused person. Stop. Under this circumstance, she submits that since trial is at the advanced stage, the petitioner may not be released on bail as paid for. Next para. I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record, including the scanned copy of the TCR that has been sent to this court. The the petitioner, as may be noticed, was arrested on 27/9/2024. On account of the recovery of the alleged contraband substance, suspected to be methamphetamine. The arrest/court surrender form annexed to the bail application at serial number 8 merely provides that the petitioner, after being informed of the grounds of arrest and his legal rights, was taken into custody. And that intimation was given to his wife apart from this, no materials have been placed before this court or available in the TCR. On the written grounds of arrest having been furnished to the petitioner. The apex court in Ms. Vaneshwamy, which was the first case? Was it? Hmm. Prabir Prakyastha, Supra. In the given facts of that case, has held that the reasons for arrest is not similar with the grounds for arrest. Stop. That while reasons for arrest may be for prevention of the accused person from committing any further offense or for proper investigation of the arrest of the offense. But in case of the grounds of arrest, the same is personal to the arrested person, and the same is required to be communicated in writing. And if not done so, the same would amount to violation of the constitutional rights of the arrested person provided under Article 22, bracket 5 of the Constitution of India. of the apex court in coming to such a conclusion had relied upon the decision of the same court rendered in case of Pankaj Bansal versus Union of India. And others reported in so and so. Stop. Considering the same, considering the ratio laid down by the apex court, it is seen that the same would squarely apply to the present case, as arrest was made after delivery of the above judgments by the apex court. Stop further. The co-accused person, who in fact was arrested for possession of 18 kilograms of suspected methamphetamine, has also been released on bail by this court by order dated 26/2/2026, passed in bail application 2 of 2026. To stop, the learned additional public prosecutor is correct in submitting that principles of parity cannot be applied simply without considering the degree of involvement of each of the accused persons. Stop. In the present case, it is, however, noticed that there are no materials to distinguish the nature of involvement of the petitioner and the co-accused person, and therefore, in absence of which this court is inclined to accept the fact that the petitioner is entitled to clarity. For being given bail. So accordingly, the petitioner shall be released on bail upon his furnishing a bail bond of rupees 50,000 with one surety of the like amount to the satisfaction of the concerned Which court is this?
Fast Track Court, Kolasip.
Concerned court, bracket, Special Judge Kolasip,
Fast Track Court.
Fast Track Court, Kolasip. subject to the following conditions. Column dash number 1, the petitioner shall not abscond and cooperate with the remaining trial. Number 2, the petitioner shall not hamper or tamper with the evidence or try to influence any of the witnesses. Number 3, petitioner shall not commit any illegal activities, including any offences under the NDNPS Act. Next para, violation of the above bail conditions will entail cancellation of the bail. Of the bail application stands disposed of as allowed.
Obliged, my lord.
Item 15.
Please, Your Lordship. Lordship, as per last court's order, TCR was called for. And if TCR has arrived, paper book may be prepared. The matter may be listed accordingly for hearing.
Why is it listed today?
The records have arrived, my lord. From the
Records. Parties are all represented.
Respondent number 1 to 3 are represented.
And who remains?
Respondent number 4.
4. Dalram Liana. Oh, what? What's his name? Dalram Liana.
Yes.
They have taken steps?
Yes, my lord.
When?
8/12/2025.
Yes, you are there for 1 and 2.
Respondent number 3. 3 only, my lord.
3 only?
Yes, my lord.
And who's for 1 and 2? What fella? Who is he? Where is he? Parties are represented by their respective councils, except for respondent numbers 1, 2, and 4. So, Mr. Lalruatfela, R. Lalruatfela, learned counsel, appeared for respondent numbers 1 and 2 on the last court date. But he is absent today, and the office note indicates that Vakalatnama has not been filed by him for representing respondent numbers 1 and 2. Sub-office note also indicates that AD card has not returned back from respondent number 4. What is that? Okay. Office note indicates that ID card has returned back, instead of not returned back from respondent number 4. On perusal of the ID card, it is seen that the same has been signed by one VL, what is this? Roton Pui. Is it Roton Pui? Roton Pui. VL Roton Pui. And the date of delivery is dated 12/12/2023. 25. 12/12/2025. However, as no one appears for the respondent number 4, appropriate orders will be passed in due course. Next para, it is also seen that the TCR has arrived. Registry to prepare a paper book at the cost of the appellant. And thereafter to list the matter for orders. No, you write like this. Registry to prepare the paper book expeditiously. List the matter again after 3 weeks. All right.
Item 16.
Yes.
Yes, may I please your lordship? My lordship, this bail application has been listed for the first time. And this application is under section 483 of BNSS, read with section 37 of the NDNPS Act. For enlargement of the accused on bail as she was summoned and thereafter arrested on 5/8/2024 by the Excise and Narcotics Team Lunglei in connection with excise case number so and so under section 21B of the NDNPS Act. My lord, on perusal of the charge sheet, it is found that there are 2 accused such as C. Lalmonsanga, who is the son-in-law of the applicant, and as well as Vanlal Remy, the instant applicant, my lord. And they were allegedly possess 185.71 grams of suspected heroin, 16 soaps, my lord, kept concealed inside 2 air purifiers at the residence of co-accused C. Lalmonsanga, her son-in-law, at Chanmari, Lunglei, Mizoram. Therefore, the case is pending before the additional district and sessions judge Lunglei, but the presiding judge has been elevated to district and sessions judge, leaving the NDNPS court vacant, with no successor appointed, as a result of which the trial stands stalled and no further proceeding have been taken up. The accused applicant inter alia contends that there is no prima facie case against her, that the applicant had no knowledge of the alleged offence, and that the seized article was never in her possession or in her own residence. Further, the applicant herein pleads that the prolonged detention without any meaningful progress in trial is causing violation of a fundamental right to life and personal liberty under Article 21 of the Constitution of India. Apart from that, my lord, the history of this case is that the applicant has been in judicial custody for almost 1 year and 7 months. And the last court date was listed on 28 January 2026. And the Apart from that, my lord, if I may take your attention to page number 17.
No, today we'll issue notice.
Yes, my lord.
Okay, nothing much to be done. Yes, Miss PP. Art, Mr. J.H. Ricky Malwat Pella, learned counsel for the applicant, who submits that by filing this application under section 483 BNSS 2023, read with section 37 of the NDNPS Act 1985. The applicant prays for his enlargement on bail. How many times you were arrested?
My lord, the instant applicant, I believe it is for second time.
First time was on 5/8/24.
No, my lord. It was on 5/8/2024 she was arrested.
That's
Sorry.
what I'm saying.
Yes,
Your
my
first arrest was 5/8/24.
Yes, my lord.
Then when is the second arrest?
The second arrest was on, she is in the judicial custody till date, my lord.
So there's only one arrest.
Two arrests, Silan Monsang and the co-accused, the son-in-law of the applicant.
No. How many applicants are before this court? Only one.
Only one.
So how many times have you been arrested? Only once, isn't
Only
it?
once.
Then why do you write here? Okay, son-in-law. You were arrested on which date?
5/8/2024.
Okay. Learned counsel submits that the petitioner was arrested on 5/8/2024 in connection with alleged recovery of 185.71 grams of suspected heroin kept in 16 soap cases. Kept in a concealed in 2 air purifiers in your residence,
No, in the co-accused Silan Monsanga's
in the
residence.
residence of the co-accused person. What happened to him? Has he been released? No,
He has been released, my lord.
he's been released. When?
My lord, that information I haven't received, my lord, since
Then how do you say yes?
I have the daughter of the applicant. The daughter of the applicant is the wife of the co-accused.
Whatever may be the relation, if you say he was released, then you should be having that order, at least the reference.
Yes, my lord.
You don't have the details also, then you say yes.
That is the information I have received, my lord.
Stop accordingly. Excise case number EXN 308/2024. Lunglei. Dated what? What is the date?
6/8/2024.
You should reflect that in the cost title somewhere, like make things easier. Dated 6/8/2024 was registered under section 21 bracket small b of the NDNPS Act 1985. So stop. Since then, the petitioner is in custody. Next para, issue notice. Returnable by. This is from Lunglei, isn't it?
Yes, Your Worship.
We'll fix a date. Returnable by 6th of April.
Your Lordship, if possible, on 9th of April.
Why?
Because I will be on leave on 6th. I will not be present.
Others will be there also.
However, Your Lordship, at this moment, only two PPs were there, Miss Linda and me.
Okay.
And Miss Mary is on leave.
Returnable by 9th of April. Registry this requisition scanned copy of the TCR. Ms. Vanessiami, learned additional PP, accepts notice on behalf of the state. Copy of the bail application be furnished to her, if not already done. List accordingly.
Obliged, my lord.
Orders are over. Come back at 2.
For admission, item number 2.
Lordship, in the last court date, government side asked for the production of the record.
Your Lordship, I'm standing on behalf of Ms. Nalin Lui. She's on leg. She has arbitration hearing at courtroom number 1. As
Isn't
per,
that-
as per her information regarding the pending records from the Office of the Deputy Commissioner, Kolasip, the incumbent Deputy Commissioner, Mr. Robert Sil Mangaya, passed away on 18 March 2026. This has understandably caused administrative transition period under the ADC, and while they are working to process our request as priority, the record have not yet been dispatched. Therefore, I kindly request 2 weeks to allow the office to coordinate and transmit the necessary documents to the Honorable Court.
You've written down a speech. It's very unfortunate, yes, the incumbent has expired the other day.
I understand that, but Your Lordship, in the letter, they're saying that they have no record as such. The letter from the SDO Sadar.
Where's the letter?
On,
Which letter?
In the last court date also, she submitted. And I have another copy. And they have given so many times for production, and at last that letter saying that they don't have such a document as such, because there's no spot verification, measurement and all. So this letter is clear that there's no such other document except in the last court date. They have produced the award, which was annexed in the affidavit also. So Your Lordship, in the the case is filed in the year 2019. A long time back also they asked for production, but they could not produce.
We ask her to come, Ms. London, please. We'll pass it over for the time being.
Yes, sir.
Okay. Take up other matters.
Item 3.
My Lord, in this matter, I am for the respondent number 1. I have received the affidavit in reply yesterday.
My Lord, I appear for the petitioner, my Lord.
Yes.
My Lord, there are two respondents over here, my Lord. One is the private respondent, second is the state. we have filed our rejoinder, my lord, to the affidavit filed by the private respondent. My lord, as per the last order, 23/2/2026, state are yet to file their counter affidavit, my lord.
Lordship,
Service
the
is
state will not
completed
be
in
filing.
effect upon.
Yes.
Lordship, the state will not be filing.
So we post it on 20th. I think there are other matters also.
My lord, 20th, my lord.
20.
20, my lord.
Parties are represented by the respective councils. Mr. Your
N. Khera, my lord.
Huh?
N. Khera, my lord. N. Khera, Nitin Khera.
Mr. N. Khera, learned counsel, appears through RVC. Ms. Caroline K. Lungogui, learned government advocate, appearing for state respondents. Appearing for respondent number 2, submits that the state respondent number 2 will not be filing counter affidavit. In view of above, and as agreed to by the parties, let the matter be listed on 20th of April 2026. Interim order passed on that shall continue till the next date of listing. All right.
My lord.
Item 4.
This is also similar.
My lord, here, my lord, we have filed our rejoinder affidavit to the counter affidavit filed by respondent number 1, my lord. In total, there are 65 respondents. State is the 65th respondent. State is yet to file their counter affidavit. However, my lord, service was awaited on certain respondents as
Yes.
per order dated 23/2/26, my lord. Respondent number 2, 6, 8, 9, 10, 11, 16, 19, 21, 25, 26, 29, 32, 34, 36, 37, 38, 39, 43, and 44, my lord. And it's still awaited, my lord, as per my instructions. And state on the last date have said they will not be filing any counter affidavit in this matter also, my lord.
My lord, in the earlier occasion, the state has
Yes. You appear for which respondent?
Pardon, my lord.
You are for which respondent?
Respondent number 1, 3 to 5, 7, 12.
Okay. All right. You have filed your affidavit.
My lord.
Okay.
And the
We have filed a rejoinder, my lord, in respect of them.
State is not filing affidavit again
My
in
lord.
this case? Okay. See, AD card has not come back from some of the respondents, and steps was
My
taken
lord.
sometime in January.
My
Correct?
lord.
January 27th. I think postal tracking can be done still. It's within
My
3
lord.
months. Within 3 months. So we'll list this matter again on
My lord.
20th, like the other matters.
My lord.
Mr. N. Khera, learned counsel, appears for the petitioner through RVC. While Mr. Nalsan Liana Kyante, learned counsel, appears for the respondent numbers 1, 3, 4, 5, 7. You just copy it from there, cost list. I'll give you, just write down. I'll repeat, 1, 3, 4, 5, 7, 12 to 15, 17, 18, 20, 22 to 24, 27, 28, 30, 31, 33, 35, 40 to 42, 45, 46, 49, 50, 52 to 62 and 64, and submits that affidavit in opposition has already been filed by the said respondents. Learned counsel for the petitioner also submits that a rejoinder affidavit has been filed against the said affidavit in opposition. Next para, Mr. Samuel Vamshi Ratsangte, learned additional advocate general, appearing for the respondent number 665, submits that the state respondent will not be filing any affidavit in opposition in the matter. Next para, office note dated 23/3/2026 indicates that AD card has returned back from respondent numbers 47, 48, 51 and 63. So accordingly, notice is accepted to be complete upon the said respondents. Stop. Then the same office note, however, shows that AD card has not come back from respondent numbers 2, 6, 8, 9, 10, 11, 16, 19, 21, 25, 26, 29, 32, 34, 36, 37, 39, 38 first, then 39, 43 and 44. Stop. It is seen that notice was sent to them by registered post with AD on 27/1/2025. Oh, this is 25, not 26, 25. Can you take fresh steps
My lord.
upon them?
My lord.
And therefore, tracking of a postal consignment will not be possible at this stage. Stop. Considering the same, petitioner to take fresh steps upon the said respondents by speed post within 1 week. List again on 24/2026. Any interim order? Any interim order passed in this case?
Yes, my lord. There is an interim, my lord.
Okay, interim order passed earlier shall continue till the next date of listing.
Item 5.
My lord,
Yes.
there are 6 respondents in total, my lord. 1 to 5 are private respondents, 6 is state. My lord, 1 to 5, respondent number 1 has been represented. 2 to 5, though they have been served, but they are not represented, my lord. Respondent 6 is state.
Okay. But Mr.
And
N. Khera,
we have filed our rejoinder, my lord.
N. Khera, learned counsel for the petitioner through RVC. Mr. Lalsan Lena Kyante, learned counsel, appears for respondent number 1
One only, my lord.
and submits that respondent number 1 has filed counter affidavit. Stop. The learned counsel for the petitioner also submits that rejoinder affidavit has been filed to the affidavit and position of respondent number 1. Mr. Samuel Vamshi Ratsangte, learned additional advocate general, appearing for the respondent number 6, submits that respondent number 6 will not be filing counter affidavit in the matter. Next para, office note dated 23/3/2026 indicates that AD card has returned back from respondent numbers 2 to 5. Stop. Accordingly, notice is accepted to be complete on respondent numbers 2 to 5. As paid for by the parties appearing today, list the matter on 20th of April 2026. In the meantime, interim order passed earlier shall continue till the next date of listing.
Item 6.
My lord, there are 37 respondents in total, my lord. 1 to 36 are private respondent and 37 is state respondent, my lord. My lord, respondent number 3, 7, 14, 19, 21, 22, 24, 27, 30 and 34 are represented. They have filed their affidavit through respondent number 24. We have filed a rejoinder to the same, my lord.
Okay.
State is represented, my lord.
So there are some respondents where AD card is awaited. So,
And for some, my lord, AD card has returned, however, they remain unrepresented. If I may assist, my lord?
for those from which AD card has not returned, you may take fresh steps again.
My lord.
Had Mr. N. Khera, learned counsel, appear for the petitioner through RBC. He submits that the petitioner has filed rejoinder affidavit to the affidavit position filed by some of the private respondents. Stop. Mr. Lalsaliana Kyangte, learned counsel, appears for respondent numbers 3, 7.
My lord.
Yes.
T7, my lord, 14.
No, I got it.
My lord, my lord.
The record is before me, so representing appears for respondent number 3, 7, 14, 19, 21, 22, 24, 27, 30 and 34. And submits that counter affidavit has been filed by the state respondents. And they have also received rejoinder affidavit from the petitioner. Stop. Mr. Samuel Wangsit Changte, learned additional AG, Mizoram, submits that the respondent numbers 37 will not be filing counter affidavit. Office note dated 23/3/2026 indicates that AD card has returned back from respondent numbers 9, 15, 16, 17, 18, 20, 23, 25, 28 and 35. Must have accordingly notice is accepted to be complete upon the said respondents. As agreed to by the parties present today, list the matter on 20th of April 2026. Interim order passed shall continue till the next date.
My lord, we may be allowed to take fresh steps. That direction may be
I'm
given
sorry,
from
yes.
the unrepresented. My lord.
In the meantime, the petitioner to take fresh steps
My lord.
For service of notice upon respondent numbers 1, 2, 4, 5, 6, 8, 10, 11, 12, 13, 26, 29, 31, 32, 33 and 36 by speed post within 1 week. Lisa, you check up from the order sheet, okay? It's all given here.
Item 7.
My lord, there are a total of 2 respondents, my lord. One is private, the other is state. 3 respondents, my lord. 2 are private and the third is state. All have been served. Respondent 1 and 2 private respondents. We have replied to their counter affidavit, my lord, by filing our rejoinder. State has stated on the last day that they will be absolving from filing any affidavit.
Oh, they have. You'll not be filing. Okay.
My lord, since pleading is complete, this case may be taken up separately at an earlier date for admission hearing, my lord.
Why earlier date? All matters are, I think, same issue.
Yeah, same issue, my lord.
My lord, it may matters may be taken up together. We only once the service is completed. It's on a point of law, so.
No, we'll have it together on 20th. Okay.
My lord, my lord.
Mr. N. Khera, learned counsel, appears for the petitioner through RVC, and Mr. Lalsaliana Kyangte, learned counsel, appears for respondent numbers 1 and 2. And they submit that pleadings have been exchanged between the parties. Stop. Mr. Samuel Changte, learned additional AG, appearing for respondent number 3, submits that respondent number 3 will not be filing counter affidavit. So, although Mr. Lalchan Lena Kiangte, learned counsel for the respondent numbers 1 and 2, submits that as pleadings are complete, matter may be posted for an early admission hearing. It is noticed that similar matters are due to be listed on 20th of April 2026, and therefore let this matter be also be listed on 20th of April 2026. Interim order passed earlier shall continue till then.
Obliged.
If I may, my lord, if I may,
Yes.
my lord, not all the matters are similar, my lord, so that similar observation may affect in the future course. Certain matters predate certain notification. So, my lord, that observation, if maybe
All right,
struck off.
then it is noticed that similar matters are said, na?
My lord, that
It is
may be
noticed
struck off, my
that
lord,
some matters filed by the same petitioner are due to be listed on 20 April 2026. All right, we have deleted that.
my lord.
Next.
Item 8.
Highly obliged.
May it please your lordship.
Yes.
Your lordship, in this matter, I am appearing for the private respondent number 5.
What is your good name?
Your lordship, my good name is A. Das, your lordship.
A. Das.
We will be filing our wakalatnama, my lord, in this matter. We pray for some time, my lord. 3 weeks time.
How much time?
3 weeks time may be granted, my lord.
Okay. And who else?
My lord, I am for the respondent number 1 and 2.
What is your name, please?
M. Smith, my lord.
M. Smith. You have filed already the counter affidavit?
No, my lord. Actually, my lord, this writ petition has been challenged by the private respondent number 5, which is appearing. The matter is fixed tomorrow. And in the Honorable Division Bench, by the order dated 18-2, have clearly stated that this petition is not maintainable. But that matter is fixed tomorrow, my lord. So we'll argue on that tomorrow, my lord. If the Division Bench has that the writ petition is not maintainable, my lord, then it goes, my lord.
18-2. I'm sorry. The division, who has challenged before the division bench? Respondent number 5.
Me, my lord.
Yes.
I have
Writ
filed. Writ appeal, we have filed one.
Okay.
Writ appeal 1 of 2026, my lord. We have challenged the order of this honorable single judge order dated 13-1-2026, my lord.
You challenged
Where
the interim order?
Yes, as well as the entire proceeding, my lord.
Okay. Any stay order?
Stay order not yet, your lordship. It is to be decided tomorrow, your lordship. It's fixed tomorrow.
Okay. What is your name, please?
Lalthang Moya.
Mr. Lalthang Moya, learned counsel, appears for the petitioner, while Mr. A. Das, learned counsel, appears for respondent number 5 through RVC and submits that he may be given 3 weeks' time to file his power as well as counter affidavit to the writ petition.
My lord, we might not be filing our counter affidavit. It depends upon the outcome of the writ appeal, your lordship. So that might not be reflected in the order, if I may request, my lord.
Then for Vakalatnama, how much time?
My lord, because it is going to come from Tamil Nadu, my lord, that is why. And
Prays for 3 weeks' time to file his power. He further submits that the interim order passed by this court on 13-1-2026 has been put to challenge by respondent number 5 through writ appeal number 1 of 2026, which is due to be listed on 25th
Yes,
of March 2026. and submits that depending upon the outcome of the writ appeal, the petitioner, the respondent number 5 will seek time to file response to the writ petition. Then Mr. M. Smith, Learned Counsel, appears for respondent number 1 and 2 through RBC. What is your submission, Mr. Smith?
Well, same thing, my lord. Since the matter has been put into challenge, my lord, if depending upon the outcome, we'll file our rejoinder.
And also submits that depending upon the outcome of the writ appeal, the respondent number 1 and 2 would make the prayer for filing counter affidavit. In view of above, let the matter be listed. When?
3 weeks, my lord.
After 3 weeks.
May I, Your Lordship? Your Lordship. May I further pray interim order, because otherwise it will not be granted, the appeal will not be fail. The purpose of the appeal will be fail. So because they also appeal in writ appeal. They also file a writ appeal, but Your Lordship, the writ appeal did not stay about the interim order.
Was it listed after that day? Again, 13/1.
Yes, fine. Yes, it was listed there. It was listed on 11/3, Your Lordship. Last it was listed on 11/3/2026. The writ appeal, Your Lordship.
Okay, so we'll continue the interim order. So you've decided against the petitioner,
Yes.
you'll take care of it.
Yes.
Interim
Since
order
there is
passed-
no, yes, sir.
Interim order passed earlier shall continue till the next date of listing, which however will also be subject to the
Outcome of the writ
writ
appeal.
appeal number 1 of 2026.
My lord.
Item 9.
Much obliged.
Lordship, I'm appearing on behalf of my senior for the respondent number 5, the Tourism Department, my lord. My lord, if I may be given another 2 weeks' time, my lord, to file my affidavit.
Respondent number 5 is what, Tourism Department?
Yes, my lord.
They are the intervener.
Huh?
He's the intervener.
Intervener.
Yes, my lord. Then, my
You
lord.
want some time for filing counter affidavit?
Yes, my lord.
How much time?
2 weeks' time, my lord.
My lord, on 11/11/2025, order was passed in respect to the filing of the affidavit in opposition. In the last paragraph, it is mentioned like this: the respondent number four is supposed to be number 5, I think so, is given an opportunity of 2 weeks time to file their affidavit in opposition in response to the writ petition. It is made clear that even in the absence of the affidavit in opposition on the next date fixed, the matter will be taken up for consideration. Then,
That was respondent number 4.
respondent number 4 had already filed the affidavit in opposition on this date. This might be mistaken, I think, clerical mistake, I think so.
It should have been what? Which respondent?
Respondent number 5 supposed to be.
It should have been respondent number 5.
Yes, my lord.
Okay, let's see.
Then on 21/1/2026 also, they are praying for filing for filing affidavit in opposition. If it may be given time, let it be for the last chance, my lord.
Why haven't you filed an affidavit?
That is true, my lord, that such orders were passed, my lord. However, my lord, the land, my lord, was to be, the compensation which has been received by the petitioner, my lord, has to be apportioned between the tourism department and the petitioner, my lord. And so if we may be given, my lord, at least another 2 weeks' time, my lord, to file our counter in this matter.
Mm, 2 weeks time was granted already last time on 11/11. Counting from 11/11/25, it's more than 2 weeks now.
21
December, January, February, March. 3
January
months, 4
also
months.
they pray another 2 weeks time.
Okay. So
January
they are
21st.
praying in installments. Why don't you pray for 1 month? Anyway, you must file within 2 weeks.
Yes, my
This is
lord.
the last chance.
Yes, my lord.
although it was indicated in the last court's order, not last court, please cancel that. When the matter was listed on 11/11/2025, time was sought for by the learned counsel for the respondent number 5. And accordingly, 2 weeks' time was granted. Stop. Be it mentioned herein that time was sought for by the counsel for respondent number 5, but the order reflects the prayer being made by the counsel for respondent number 4. Stop. Court is informed that Mr. J.C. Lanunsanga, learned counsel, appears for respondent number 5, not respondent number 4. Stop. Therefore, the prayers were made and time granted would be considered as a prayer made by the counsel for respondent number 5. Next para. Subsequently, the matter was listed again on 21/1/2026, wherein further two weeks' time was granted to respondent number 5 for filing counter affidavit. Stop. Despite the same, affidavit has not been filed till date by respondent number 5. Of Ms. Stephanie learned counsel for the learned counsel appearing on behalf of Mr. J.C. Lanunsanga, counsel for respondent number 5, submits that further 2 weeks' time may be granted for filing the counter affidavit. There must be a reason behind, otherwise, what is the reason behind?
My lord,
You're in a fix. Anyway, the said prayer is opposed to by the learned counsel for the petitioner on the ground that enough opportunity has been granted to respondent number 5. But if time is to be granted, the same should be as a last chance. Stop. Considering the above, 2 weeks' time is granted to respondent number 5 as a last chance. List again after 2 weeks.
Much obliged.
deeply obliged.
Item 10.
Contempt case.
May I please, Your Lordship?
Yes.
My Lord, on the last occasion, 3rd of February, my Lord, the Respondents' Council has been given time to file additional affidavit to clarify the stand taken by them. In fact, they have already filed the respective affidavits by all the respondents. And on the basis of the affidavit, the stand taken by the respondents, my Lord, this court on 19 January 2026 had taken into consideration the documents, the stand taken relied upon by the respondents, my Lord. And specific observation was made to clarify on the stand taken by the respondents.
So why is it listed today?
My Lord, on 3rd February, my Lord, the Respondents' Council had 6 time for filing additional affidavit to clarify the stand taken by them. And they were given 2 weeks' time. Now it's been more than a month, yet they have not filed an affidavit till date. And in the meanwhile, my Lord, This judgment order, which I'm seeking to implement through this contempt petition, my lord, has been disposed of by this court, relying upon the other case, my lord, other precedent, which was already complied by the state respondents in other case. They are only delaying the matter, my lord, while the petitioners were waiting for the outcome, the benefits of this judgment. Until today, no affidavit has been filed as directed by this court.
Yes, what do you say?
Your Lordship, I'm standing on behalf of Miss Mary. Yes, we have received instructions. We'll be filing affidavit regarding the latest order.
You are appearing on behalf of
Miss Mary.
Mary-
She's on leave.
Mary L. Kyangte?
Yes, Your Lordship.
When will you file the affidavit?
Your Lordship, we have already filed affidavit, but we are yet to be filed the additional affidavit.
That is what, when are you going to file the additional affidavit?
Your Lordship, if you may kindly grant us another 2 weeks so that I'll file on her behalf.
My lord, they have been granted time since 3rd of February, and before that also, my lord, 19th of January. Now we're in the end of March. And the other connected case has already been complied with.
So we'll give them one more chance and with an observation.
Yes, my lord.
Although time was granted to the respondent numbers 1 to 5, correct?
Yes, my lord.
To file additional affidavit in terms of the court's order dated 19/1/2026. But the additional affidavit is not yet filed. Till date. Stop. It is seen that when the matter was listed on 3/2/2026, further 2 weeks' time was granted for the said purpose. But when the matter is listed today, a prayer has been made once again on behalf of Ms. Mary L. Kyangte, learned counsel appearing for respondent numbers 1 to 5, seeking 2 weeks' time to file counter affidavit, to file additional affidavit. It is also submitted that Ms. Mary L. Kyangte, learned counsel, has submitted leave of absence up till from 17/3/2026 to 24/4/2026. Considering the same matter be listed, let the matter be listed on 28th of April. So if the affidavit is not filed on or before the next date fixed, it will be presumed that the respondent numbers 1 to 5 have no affidavit to file. And therefore, the contempt petition will be considered on the basis of the materials available on record. Alright?
Deeply obliged.
Item 11.
My lord, this contempt petition has been filed for non-compliance of the order passed in WA number 11 of 2024, dated 17 to 25. My lord, there are 5 respondents in this case. Respondent number 1, 3, and 4 are now represented. And in respect of respondent number 2 and 5, service report or ID card has not returned back. That is reflected in a note sheet dated 19/3/2026. If your lordship may allow me at this stage, if I may be allowed to produce the order passed by the Honorable Supreme Court, wherein the NPCC has filed an appeal against the order of the division bench of this court, which was dismissed by way of SLP, my lord.
No, before that, what was the order passed in the
The order passed.
single
Single judge says that since there are disputed question of fact, that we have to avail the alternative remedy.
Okay, what is the matter regarding?
The matter is regarding land compensation, border fencing. There was an award made by the DC, which was subsequently approved by the state government. It amounts to 31 crores something. And then thereafter, we have challenged the order of the single judge. Then the Lana Division Bench has accepted our prayers and directed the respondent to pay the awarded amount, along with the interest under Section 34. Now, being aggrieved, the NPCC has filed SLP against the order of the Division Bench. Now that SLP was dismissed by the Honorable Supreme Court, via order dated 2/2026. Your Lordship, allow me, I'll place this along with the assessment made by the DC.
Who appears for 1, 3, and 4? 1. And
3 and 4.
3 and 4.
Your
1, 3,
Lordship,
and 4.
we will be representing respondent number 5, and we have filed our report this morning.
5.
Yes, Your Lordship.
So who remains? Only 2.
Only 2. We cannot wait for the service report, my lord.
Mr. Silal Fagzwara, Learned Counsel, appears for the petitioner. Only one petitioner.
Yes, my lord, in this contempt, my lord.
While Ms. Zaidam Sangpui, Learned Counsel, appears for respondent number 1. Come on, Mr. Roshan Subedi, Learned Counsel, appears for respondent numbers
3 and 4.
3 and 4. And Mr.
Daniel Shasel on behalf of Miss Mariel Kiangte for respondent number 5.
Daniel Fasel, Learned Counsel, appears on behalf of Miss Mary L. Kyangte, who will be representing respondent number
5.
5. What about your wakalat number?
Yes, Your Lordship, we have filed this morning.
Okay. Accordingly, formal notice on respondent numbers 1, 3, 4, and 5 is waived. When did you take steps for respondent number 5? Okay.
29/1/26.
Who is respondent number 5?
5 is Vanal Moya, Secretary, Land Revenue and Settlement Department, Government of Mizoram.
You took steps on
29/1/26.
It's not, okay, is it reflected anywhere?
The first step is on 22nd 9/2025, my lord.
29/1/26, where is that? I've not seen anywhere. But
Perhaps your lordship may kindly see 22nd 9/25.
we're talking about respondent number
5.
5.
Yes, my lord.
5 or 2?
5, now he's represented.
No,
Yes.
I'm talking about respondent number 2.
Respondent number 2.
Mm.
Steps were all taken on 22nd 9/25, my lord.
No, you have taken steps again, I think.
Yes, my lord. On 29/1/26, if I'm not mistaken, my lord.
No. What is the date? It's 23rd February 26. No, not 20. This looks like 5. This is 26. This is the date, I think. It is seen that notice was issued to respondent number 2 by. How was it issued? Who's writing all these office notes? I think they have to be careful. (24/2/26), anything like that? Receipt? By what? Speed post? Notice was issued to respondent number 2 by speed post on 24/2/2026. And therefore, let service report be awaited from respondent number 2. Next para, at this stage, Mr. Silal Pakzola, learned counsel, submits that the order of the division bench, which according to the petitioner has not been complied with by the respondents herein, was put to challenge by the National Project Construction Corporation Limited before the Apex Court. By the Apex Court, void order dated 2/2/2026. While condoning the delay in filing the SLP, declined to interfere with the order passed by the division bench. Stop. Under this circumstance, he submits that there is no further option for the respondent and PCC but to comply with the order passed by the division bench. Stop. To support his submission, learned counsel has produced a copy of the order dated 2/2/2026 passed by the Apex Court, which is being kept on record and marked as X for identification. Yes. Now, what will you do? NPCC.
Yes, Lordship, we may be given time to file our so-called reply to the contempt petition. So 3 weeks time may be granted.
3 weeks time.
Yes.
As paid for, the respondents are granted 3 weeks time to file their compliance report. list again after 3 weeks.
My Lord, in the meantime, if your lordship may kindly, I have submitted a letter in which the DC has made an assessment under section 34, which I have inadvertently not annexed in this contempt petition. My Lord, the original amount of award of rupees 31 crores 99 lakhs 91,282 has been enhanced to 90 crores 95 lakhs 45,469. Now, if your lordship may, if it please your lordship, if your lordship may reflect that in the order. But if your lordship insists, we can also file an.
It is better you file an affidavit.
Yes, my lord.
The petitioner is also granted liberty to file additional affidavit incorporating subsequent development in the matter.
Yes, my lord. And that has been acknowledgement.
In fact, is the revision of the assessment made by the collector, correct?
Yes, my lord. That has also been acknowledged by the NPC in page number 84 of my writ petition, contempt petition.
All right.
Obliged, my lord.
You take back this copy.
Item 2.
Yes, your friend had read out something. You had given him something to
Yes,
read.
Your Lordship, it was tentative. Your Lordship, as per the order dated 18/3,
See, we had given you time
yes, Your Lordship.
on the ground that you had said that you had some telephonic conversation,
Yes, Your Lordship.
that there are some records which are bulky records and you'll be able to produce them.
Yes, Your Lordship. If I may be allowed to produce the same on the 27th, Your Lordship.
Your Lordship, I have objected here. She herself saying on 16, it's clearly stated, on 19 to 2026, when the matter was listed, the learned government advocate submitted that the records are lying with the establishment of Deputy Commissioner, Kolasip District, according to the Public Works Department, and the same are being requisitioned. However, instead of producing the original record, the state respondent have filed an additional affidavit incorporating the photo of the report of the verification. So, Your Lordship, they admitted that whatever record they have was enclosed in the affidavit. And again, on 18th, Your Lordship, the letter of the SDO Sadar was submitted, and thereby it's clearly stated that there is no original as such. There is no actual land area assessment of actual land area and numbers of the maize crop could not be determined, as the land in question is already devastated by the execution of the construction of works. So what else they need, Your Lordship? They keep on giving time since 2021. And in this court, recently, 30 of January, given a time to produce the records. And they say that whatever records they have was enclosed in the affidavit. And the same was produced on 16/3/2026, and the original, which was produced, is previous award and the reassessment award. And Your Lordship, what else you are waiting for? Since 2019.
All right, see, Mrs. Dinari, see, the thing is that on the last court date, we had made an observation.
Yes.
As per the submission made by the GA, that
yes.
according to our telephonic instruction, there's some records available. So we wanted that to be produced, and
Yes.
today was the date.
Yes.
But now they say that because of the demise of the DC, it's
Yes.
difficult to produce. So I think we should give them one more
But
chance.
Your Lordship, the
I can produce
contradiction
it.
is there. Herself submitted
Your Lordship,
on
there is no-
16/3. She's saying that there is no such other
That is the instruction that was given
records.
to me, Your
And
Lordship.
on 17, the SDO Sadar also saying that. So what else we are waiting? They keep on asking since 2021.
So we'll make it clear this time.
Yes. And Your Lordship,
if
I
they are-
want to submit that in a similarly situated person, those who have given more amount compared to the previous award, those people have given, they have approached reference court and the square feet rate was enhanced, and again, they have given solicium interest. Now, it's pending for quite a long time. We are late for that also, Your Lordship. All are similarly situated. They have received, including enhanced amount and solicium and interest, but it's pending for quite a long time, this case, Your Lordship.
No, see, I think your basic grievance is that the initial assessment was more.
Yes.
And when it was revised, it
Yes.
became less.
Yeah, for us it's
And-
less. Some
and-
are more.
And that's why you're saying that on what basis have you deducted?
Yes.
What is the basis?
That
So
is
that's why we
correct.
said give the records, we'll see what is the
Yes.
basis.
Your Lordship, what I
And,
mean to say is that it's pending for a long time, and we have given since 2021 to
No, that's
produce
what
the
I'm saying.
same.
I'm coming to that, Mrs. Dinari. That is why, see, while such is the position, then whatever remedy was available to you for reference, you could have gone with the amount that you have received, isn't it? But you have preferred to come before this court through this
Right.
writ petition.
That is correct. What I feel is that, in my opinion, after giving that award, the previous award, I have a opportunity to ask for the enhancement for the red. Now it's only award. Since in our case they deducted, but other case they are giving more. That's why they didn't come for this court. That is only us, it's deducted.
Obviously.
Yes.
If they're getting more, they'll keep quiet about it.
Yes, yes, that's right. And they have approached reference court and they have received all the enhanced amount as well as interest, solicium and interest. So we are a bit late now. So that's why now it's a time to dispose this case.
Okay, please write. Parties are represented by the respective councils. To stop. The matter has been fixed today for production of the relevant records pertaining to the assessment that has been made after re-verification. Stop. Ms. Lalnun Louis, learned government advocate, at the outset submits that since the incumbent deputy commissioner of Kolasip district had passed away a few days back, and therefore there has been some difficulty in gathering the records for production before the court. So she therefore prays for further time. When can you produce?
Your Lordship, I will be able to produce it on the 27th.
27 is Friday.
Yes, Your Lordship. We are also attempting our best to assist the court, do our best efforts, Your Lordship.
What did you say? What did you write? No, read the last part only.
Which document they are going to produce, I don't know, Your Lordship. Let her specify. since she stated that whatever document they have is enclosed
Your
in
Lordship,
the-
even I am not aware what documents are still prevalent, whatever they have all the notings as required, as requested by the court in the previous order as well. Whatever is available to the office, Your
Oh,
Lordship.
yeah, by perusing the letter 17 March. Lordship,
What did I say?
It's
From she, therefore, you cut. She submits that she will be able to produce the records by 27th of March. On 27th of March, 2026. Next para, in view of above, list again on 27th of March, 2026. Stop. It is also made clear that if the records are not produced on the next date fixed, it will have to be presumed that there are no records to be produced. And under the circumstance, the court will have to proceed with the matter on the basis of the materials available on record.
Your Lordship, the letter 17 March 2026 be in record. The letter submitted by 17 March 2026 by Sub-Divisional Officer Sada. This be in record.
No, this you mentioned on that day. As of now, will not say
Yeah.
anything.
She submitted on 18th.
Was it reflected on 18th?
No, not reflected. That's why, Your Lordship.
Okay, you keep this with you.
Yes.
See, what we had done on that day was after this production, I had asked her to find out. So she
Maybe,
went and
yes,
gave a
yes,
call.
yes.
She came back saying that
Yeah,
it is there. So
right.
that's why I did not mention this.
Yeah.
Okay, rest assured, if you don't produce on that day, then we'll have to go ahead
Yes,
with-
Your Lordship.
in whatever manner would be befitting.
Yes, Your Lordship.
All right.